afternoon. I'm Kenney Baden. I have breaking news for the Law and Crime Network. Jeff Sessions, the Attorney General for the United States of America, has tendered his resignation. Yes, Jeff Sessions, the Attorney General, let me say that again, for the United States of America, has tendered his resignation. There is a tweet from Donald Trump, who announced that Matthew G. Whitaker, the Chief of Staff to the Attorney General Jeff Sessions at the Department of Justice, will become our new acting Attorney General of the United States. He will serve the country well. He further tweeted, "We thank Attorney General Jeff Sessions for his service and wish him well. A permanent replacement will be nominated as a later date." As you know, there's been a lot of friction between Jeff Sessions and the President of the United States, Donald Trump, and it has now come to pass that indeed Jeff Sessions has finally tendered his resignation. This is an amazing development. A day after the elections that occurred in the United States of America, it appears that Donald Trump will want to go into a different direction with a new Attorney General. Again, there was friction for a number, really the past 2 years, when Jeff Sessions became Attorney General and announced that he was going to recuse himself, which means step away from making any decisions or any decision-making on the Russian investigation. All right? So again, you can go to Donald Trump's Twitter. You can go to our Twitter. We have to go back to what we do best right now, which is the trial that we have been covering in Florida. It's the case of Florida versus Baptista. Mr. Baptista is being charged with manslaughter for the death of one Mo Knight. Let's go back in the courtroom. Well, we have a witness on the stand in this case. Her name is Melanie Peluso. She is an officer with the police department that was investigating what she thought was a stabbing at that time of Mo Knight. And it turns out that, as we know, he eventually died. So she was just giving us a documentation as to what she was doing when she was called out. She followed the previous witness on the stand, which you all watched, who was Officer Cruz, who really was more of the CSI crime scene witness who took video. And just to bring you up to date, what was important about that was the crime scene video person saw a bottle, which turned out to be a beer bottle, broken beer bottles in the car of the decedent. Now, I try not to call him a victim right now because we don't know whether he is a victim. Sure, he died. It was terrible. It's awful. But when you're in a courtroom, you try to use the word decedent if you are a defendant so that there is no prejudgment by the jury about your client, because isn't that what Mr. Baptista is on trial for? Whether or not he improperly, illegally committed a criminal act which helped cause the death of Mr. Knight on that evening. Okay, so we have a guest here to discuss it. You've seen him before. His name is Steve Greenberg, right, Steve?
Yes.
Okay, good. How are you? Now, Steve is amazing, a trial lawyer. He has a lot of experience trying high-profile cases. Now, let me ask you this, Steve. When you're in a case such as this, where the victim may have been killed by two people, and the victim may have also been an assailant, what is your defense? What is your best defense? What do you do?
Well, obviously, they're going to raise self-defense, and you have to make the victim the aggressor. It's an unfortunate incident, what happened. Nobody wants anyone to die, but it was him or us. And you have to place the jury.
Let me just ask you one question here. Are you, as a defense attorney, concerned with whether the victim was an aggressor, or do you just listen to your client, and your client tells you the victim was an aggressor, and you go out and prove it? Do you have to do an independent investigation, or what do you do?
Obviously, we're never there. Now, there's video nowadays, so that makes a difference in a lot of cases. But if your client tells you that the other person was the aggressor, you got to go find some physical proof of that. Maybe your client has defensive wounds on them. Maybe, like in this case, there's a broken beer bottle that's found that's consistent with what your client's telling you. So if just your client's saying that, you better have something else to back it up.
Well, let me just give you this final question. If you are the defense in this case with Mr. Baptista, do you foist the blame not only on the decedent, but also on Mr. Elder, who you know has already been convicted of something?
You might be able to. It's tough, though, because then the jury is going to say, well, someone else was convicted, and they probably raised the same argument and lost. So it's a very tricky road to go down. Okay, so we're going to see how the defense attorneys continue to handle that and how the prosecution attempts to prove their case right back into the courtroom. I think we're going. I'm going to hear from my producers. Actually, we're going to go to break first, and then we'll be back.
as you all know, because you follow trials, a lot of times there's a sidebar where the attorneys are discussing something the jury cannot handle or cannot see or legally is not supposed to hear or see. We are in one of those sidebars right now. We have our eye on the courtroom. As soon as the attorneys come back to watch, we're going in the courtroom. Sorry, Steve, we can't get you back into the courtroom. We go. Okay, so this is the boring part of a trial, when you identify evidence and you mark it so it's in the record, and if there's an appeal, you can identify it from that. Steve Greenberg, the prosecution here went to Officer Peluso, who's on the stand, and just handed her items and all. I'm feeling a lack of passion in some way in setting this up. What about you?
It's a bit of a methodical prosecution, I'll give it that. Some prosecutors are like that. Sometimes they just want to be very businesslike, and there's no question, no emotion brought into it. If I was a juror, I'd be bored out of my mind watching that.
I found as a defense attorney and also as a prosecutor, I could tell how the other side felt about the case in the way they tried the case, even doing things such as identification and marking exhibits in, that you could tell. How about you? Did you feel that you could tell how she feels about her case in any way?
I think she doesn't really want to be there some of the time. I definitely get that sense from her. She should have all this done. She should have gone over this with the witness. The witness should be able to quickly look at the items. She should say, I showed you these in my office earlier, and move along. Jurors don't want to sit there and just watch people go through things that should have been done, preparation that should have been done already.
Okay, so
it makes it seem like they're not interested.
So they're showing pictures, so we're going to go right back into the courtroom and see the photos ourselves. Okay, while they are doing this, we are going to go to break. We're going to be back on the other side. Hopefully, they'll be a little further on. We can then talk to Steve Greenberg about what is really happening in this courtroom. But Law and Crime has to take a break. We'll be back to the trial dealing with Florida versus Baptista. Welcome back. I'm Linda Kenney Baden for the Law and Crime Network. We are following the case of Florida versus Armando Baptista, who's on trial for manslaughter in the death of one Mo Knight. But earlier today, while the testimony here is going to identification of 89 photographs, we're going to leave that because there was some incredible testimony on cross-examination from the CSI, that's the crime scene investigator, who was at the scene of where Mr. Knight was fatally stabbed. So we're going to listen to some of that cross right now. Well, this is Lisa Cruz on the stand. She was the crime scene investigator when the police thought all they had at that point was a stabbing, but as opposed to a homicide, which is the death of a person by another, but a stabbing of Mr. Knight by either or both of the two people in the car. One is Mr. Elder, and the other one is the person on trial now. That's Mr. Baptista. Now, what was quickly sum up what was important in her testimony there was she said, number one, there was no solo cup, which means that the story of Miss Jambolis, the girlfriend of Mr. Knight, who said that Mr. Knight approached the car with a solo cup, may not be a true story. And she also said, this is important, that there was a broken bottle, it turns out to be a beer bottle, with blood on the beer bottle and blood inside the car. We don't know whose blood it is yet. So let me bring on my guest, Mr. Steven Greenberg. Steve, I got a big difference of passion, distinct passion, between this defense attorney and the way the prosecution is handling the case. Now, when you have a case where the forensic evidence may not help you, why as a prosecution do you continue to prosecute that case if indeed it's not going to help her?
Because sometimes you just got to put your case on and put it in the hands of the jury. One of the things that I've noticed over the years is prosecutors are out to win. Winning and losing is more important than necessarily figuring out who should get charged. That's an unfortunate commentary on what's happened. Here they've got a witness who says that someone was stabbed and someone died. And whenever someone dies, prosecutors aren't going to walk away from the case and say, well, the person who died was wrong, unless it's clear cut that they were the aggressor.
Well, but the history of this case is that in the grand jury did not go along, which is amazing to me because you know us prosecutors, more prosecutors, we can indict what's called the ham sandwich, maybe even 2 slices of bread these days. The grand jury only indicted for manslaughter, not murder, when the prosecution wanted murder. And then the prosecution in the Baptista case reduced the charge to manslaughter themselves, obviously, considering Mr. Elder, the other co-defendant, was not indicted for murder. So they knew there's a problem with the case. What if it turns out, and we don't know the answer to this, that the blood on the beer bottle belongs to Mr. Baptista, as he claims it is, that he was actually the victim?
So the prosecution is going to make a big deal of the fact that when they visited Mr. Baptista 2 weeks later, he didn't have any head injuries, he didn't have any cuts. But if it comes back that the blood on the beer bottle is his, then that confirms his story. Then the prosecutors shouldn't have pursued the case because there's no explanation for his blood getting on the beer bottle unless the now decedent was the initial aggressor.
Well, we're going to talk more about that, and we'll discuss whether or not there were any cuts on Mr. Baptista. But first, we're going to see what more we learned from the CSI person, Lisa Cruz, who's on the stand about this case. Whoa, you know that I all love forensic evidence. I think I'm just having a heart attack here on the set. This is Lisa Cruz. She is the CSI, was there to investigate what they thought was a stabbing, although it turned out to be a homicide because Mr. Mo Knight later died. And she found broken glass of a beer bottle inside the car on the passenger side where Mr. Baptista, who said he was assaulted by Mr. Knight, was sitting. And it had what she appeared to see as blood on it, and she is a crime scene person. And they have what's called a presumptive test, and she thought it looked like blood, but she didn't even swab it to see if it is blood. Now, if that is evidence that is crucial to Mr. Baptista's defense, Steve Greenberg, I would be making a big deal of this later on if it turns out they didn't test this. What about you?
I'm speechless that she said she didn't test it. And there's apparently no evidence that they did test it. Now, you know, the jurors may wonder whether the defense tested it, and then you got to explain to the jurors that we don't have to do anything, which is, again, another tricky argument because they'll be like,
you don't want to get the burden. You don't want to get yourself as a defense attorney into having the burden of proof.
Right. But the prosecutor should have. If someone claims they were attacked with the beer bottle and the other person was the aggressor, the prosecutor should have had that tested, even if the police didn't. So I'm speechless.
Well, in one of the testimonies earlier on, they went to the house of Mr. Baptista like almost 2 weeks later, and he had a cut on his elbow and he had a cut on his lip, but they didn't believe his story that he was assaulted with the beer bottle because they said he didn't show any evidence of any wound on his head, but they didn't take him to a hospital. Now, if the defense of Mr. Baptista is he was assaulted and then he took Mr. Elder came to his rescue and then the knife somehow got in his hand and he feared for his life and stabbed him, does that count if he stabbed him more than to get him off him? It's kind of tricky, isn't it? What if one stab wound would do enough? And there's 8 or 5 or 3 or 2 or 10?
I think that, you know, you have to say, you can't say whether 1 was right or 2 was right. The bigger problem here is that you've got someone saying they were attacked, you've got blood on a beer bottle. How did the blood get on the beer bottle? Beer bottles don't get broken when you're just drinking beer, and blood doesn't get on beer bottles when you're just drinking beer. So if I was the defense, I would just be focusing on that. Any injury he had by 2 weeks later, yeah, it healed. It doesn't say, the law doesn't say you have to have a brain injury from a beer bottle to act in self-defense. Someone comes at you with a broken beer bottle and they start swinging at you. I think any juror is going to think you got a right to stab that.
Wow, what a case. Well, we're going to talk more about it at the other side of this break. We'll see, again, we're monitoring the courtroom. We'll see if we go back there or continue with the testimony of Ms. Cruz, but stay tuned because this is amazing. Well, the person that's on the stand right now is Officer Lisa Peluso. She's testifying off the photos that were identified before the jury took their break. There are 89 photos. She just went over and showed what appeared to be a broken beer bottle that is on the roadway, which is consistent certainly with the stand that Mr. Baptista has claimed that Mr. Knight was the aggressor. She also showed a whole beer bottle, and previously, before we got into the courtroom, she said she was never asked to look for a red Solo cup. Steve Greenberg, Does this make the prosecution case stronger or weaker?
Makes the prosecution case look like they don't want to do their job and they don't want to search for the truth. The beer bottle's not going to be on the roadway unless someone put it there. Someone got out of the car, had the beer bottle. The solo cup isn't found, means it doesn't exist. Means you can argue that she's lying about it. It's the deceased girlfriend. She has every reason to lie. She's not going to say he got out of the car and attacked these people. So no one's going to believe her unless what she says, her story, is confirmed by the physical evidence. And to me, it looks like nothing in the physical evidence confirms her story.
Well, interestingly enough, Steve, we're going to continue to talk about this because we should tell our viewers that right now we lost the feed in the courtroom, so they're not missing anything because no one, except if you're sitting in Florida in that courtroom, can see anything right now. And as soon as we have it, we'll go in. But let's talk again about the fact that at the time they were called to the scene of a stabbing, they didn't know they had a homicide at this point because he's not pronounced at the scene. I believe he's pronounced at the hospital later on. Does it make a difference? I've just heard that indeed we do now have the trial, so we'll get to that question on the next break, but let's go back in the courtroom. So this is Melanie Peluso on the stand. She's from the police department that investigated the stabbing at that point of Mr. Mo Knight. We now learn why the house hasn't been identified. It's just for reference as to where the scene of the stabbing was, so they could identify the house in reference to the items on the ground. We know there's a beer bottle. We know there's blood. We know there's money that went to the lab. We're going to see more about this case when we come back, but right now we have to take a hard break, and stay tuned with us. Okay, so we're following this case, the Florida case for the alleged, I should say, manslaughter death of Mr. Mo Knight, but by Mr. Baptista. As you can see, the attorneys are in the sidebar. It's a good time for me to talk to Steve Greenberg, who's sitting patiently by. Steve, we have a question from our chat room, and people in our chat room know these cases probably even better than you and I. And I'd like to go to a question by V. Garrig, G-A-R-I-G, V. Garrig, who asked, do you think the slow pace of the way the prosecution is presenting this, do you think that the jury will resent the state? And then I'll ask you the follow-up question to that. If they resent the state, is that fair to who right now is the victim in this case, who died, Mr. Knight? Take it away, Steve.
I like to hope that they would hold it against the state, but in the prosecution, but I'm a defense lawyer. I find that as a general rule, and there will be exceptions, that the defense presentation is almost always more interesting to the jurors because of just the pace that it follows. Defense lawyers are typically more dramatic, and just the rules of evidence. So a prosecutor's stuck doing this methodical evidentiary display and chain of custody, which the rules require, and they have to ask questions. What happened next? What did you see next? How did this happen? Whereas with the defense, you can lead the witness.
Steve, I have to cut you off here a sec. I have to cut you off because they started back in court. We don't want to miss a question. I'd like to bring Steve Greenberg in, again, who's been watching this. Steve, while the beer bottle evidence that they found at the scene is being shown to this jury, can you tell me that if, let's assume they did DNA swabbing on that, and I don't know, if the victim, and I really shouldn't use the word, if the decedent's DNA is not on that beer bottle, but Mr. Baptista is, does that change the flavor of the case? I mean, the question basically is, does it matter whose DNA is on that bottle?
It matters if there's DNA on the bottle. So if they get no DNA off the bottle, then it's sort of neutral. You can argue that there just was no transfer. There's a lot of explanations for that. If they get either Mr. Baptista's DNA off it, but not the decedent, or someone else's DNA off it, then you could say the bottle was there all along and maybe Baptista picked it up to attack the other guy before he got the knife. So it can be twisted all sorts of ways. I don't think the beer bottle was handled properly by the police. I don't think it's been tested properly. From everything I've heard so far, this is really the mystery of the case.
Well, we're going to see if they tested it. So let's go back in the court. Let's listen to see what she's saying about the beer bottle right now. Okay, Steve Greenberg, who just watched that, the whole testimony, I think, on the bottle was that she said that they tested it. I didn't hear what they tested it for. Maybe our chat room can help me. And you know, it's going to take a while because you see that she's going to identify it, open a lot of other bags here. Now, what were they supposed to test it for?
Well, you want them to test it for, like you said, DNA. You want them to test it for blood and serology work. Knowing this prosecution, they probably just tested it for alcohol.
Well, that doesn't make much of a difference. But indeed, I mean, let's look at it this way. Should they have gone back to the party, for instance, and say, hey, was was the decedent drinking beer? Did he leave with a bottle? Or did you see the victims having a beer bottle? Should there have been further, shall we say, feet on the ground type police work versus testing?
Absolutely. Well, there should have been both. But there should have been, was this beer served at the party? Are there other bottles like this found in the car? We don't know any of that at this point.
Okay, so anyhow, we are in the trial. We're following the trial of Armando Baptista. It's the Florida case where this is the co-defendant. The other co-defendant was actually tried earlier, Mr. Elder, earlier in the year. We are following it. The evidence is being monitored. We're monitoring, but we have to take a break. So stay tuned with us. Come right back, and we'll be discussing this further. Well, Officer Peluso seems to be done for the day, which may mean that court is done for the day. We'll keep an eye on that. But I want to introduce to you somebody who was on with me last week, Francey Hakes. Francey, are you there?
Hi, Linda. How are you?
Hi, how are you? I know that you, last week we talked about the King case. This week we're on this Armando Baptista case. I know you have been following it. Now, right now we're talking about the collection of evidence. Now, in cases you prosecute, do you try to make the collection of evidence really smashing in terms of pace and all, or do you do as this prosecutor's doing, making sure it goes in, the jury has it, they understand it, and it's very deliberate?
I think I pick option number 2, Linda. I go with deliberate. You definitely want to make sure the jury hears everything, because when you've got 12 people, many of whom are taking notes, some of whom aren't, it seems like every juror picks up something different. So you want to make sure you give them all of the information in a deliberative way so that every juror can refer to every other juror when they don't remember exactly what happened inside the courtroom, especially when it comes to evidence.
Yeah, interesting. It just goes to point out that, you know, we watch so many trials that there's so many different styles. And one of the things that we did earlier today in this courtroom is the prosecution had opened earlier in this case, and she mentioned the name of Mr. Elder. Now, Elder, as people who in our chat room are following us and asking questions all day know, was convicted of a lesser included crime to involve possibly 1 year in jail for the death of Mr. Knight. But when Elder was mentioned by the prosecution, there was a huge mistrial objection, and I want to go to that. Do we have that ready, or should we continue talking with Francey? Okay, so let's go to that right now, and then Francey, we'll come back and talk with you. Well, it's unusual to have a motion for a mistrial right after a prosecution's opening, and I'd like to discuss it with my guests, Francey Hakes and Stephen Greenberg. Here we had what's called a motion in limine, and as our viewers know, that's to limit the testimony that may come in. And here there was a motion in limine made by both sides. One side said that the prosecution, they didn't want the fact that the lesser included was the verdict that the jury in the Elder co-defendant case was deliberated on and found. The defense basically had that didn't want any mention of stand your ground or anything of Mr. Elder. Now, tell me, Francey, why that's important for the defense in this case to have made that argument.
Well, motions in limine are always important for both sides because both sides have a stake in deciding what the jury should and shouldn't hear. And when it comes to a motion in limine about hearing that another jury found a co-defendant guilty of only a lesser included, the defense is not going to want this jury to think they can do the same. Well, the defense is going to want the jury to think they can do the same thing. So the prosecutor wants to keep that information out. And when it comes to defenses that are at cross purposes, the defense always has an interest in keeping that information out of the jury.
And Stephen Greenberg, the judge said that the prosecutor didn't violate it because the prosecutor said that the Elder was for another jury. Now, he used the word was, mimicking what the prosecutor said, for another jury. Do you see any problem with the ruling when the prosecution said, basically told that there was another jury?
I don't think that one jury should ever know that there was another jury, although they'll speculate and they'll now wonder what happened. I do think moving for a mistrial during opening statement by the defense is a good move. And the reason why is it puts the prosecution on their heels. It lets them know you're not going to let them get away with anything. They're going to be nervous. They're not going to push the envelope as much. So it's a good defensive move, even if you don't think you're going to win the motion.
Well, in terms of one other question I'd like to throw to you, Steve, and we were talking about it before the other break, when the prosecution uses crime scene, doesn't that indicate that there's a crime committed as opposed to, hey, the jury is supposed to see whether there is a crime beyond a reasonable doubt and whether this defendant did it?
Well, the jury's supposed to determine whether the crime charged occurred beyond a reasonable doubt. But in this case, even the defense is saying a crime occurred. They're saying that this guy got out of the car and attacked.
Good distinction. That defense needs a crime to occur too. That it was the victim or the decedent who was the assailant. We have to go to break. We'll be right back after we take this little break. Please stay with us. Well, that is the defense opening statement. And let me tell you, Francey Hakes and Stephen Greenberg, I am so impressed with that because in the first paragraph, what did she lay out? She laid out the case that she has, even though she doesn't have to prove it, technically, that it's the most terrifying moment of her client's life, that all of a sudden he's getting pummeled by this person who was at a party, and he pulls out something, a pocket knife that he has for work, not for as a weapon, right? And that he engages in self-defense. So she just put the case in a nutshell. Are you as impressed as I am with this, Francey?
I am, Linda. This is textbook. She lays out her theme. You know, you just don't see attorneys doing this in court anymore, and it's something a jury needs. It's the roadmap. She lays the theme, the theory, right up front in dramatic fashion. I was impressed.
Well, Steve, you know, the research tells us that jurors get a bent after an opening statement. About 70% of them get a bent. They don't necessarily make up their mind, but they have a leaning. Now, if the defense opens like this, as she thinks she does, what can the prosecution do to come that will undo what the defense just did, which really basically just said, hey, this case is self-defense, go home, ladies and gentlemen?
Well, typically when the prosecutor sits down, my client feels like there's no reason going to trial because he's lost based on the prosecutor's version. So what I like to think is at least you can convince the jury that you're back to even. Listen to the evidence and let's see what happened. She's doing a good job of that. One of the things I'd like to know, is there broken glass in this car? Because she was very descriptive. He broke the beer bottle over his head while he's seated in the driver's seat. Is there physical evidence? She didn't follow up with that. I would have followed up with, you're going to know that's what happened.
Well, maybe, Francey, maybe it's the prosecution's burden, and they didn't follow up by going to Mr. Baptista right after this, day after, and bringing him to a hospital so to have somebody check him to see whether he was bruised. Because we know 10 days later he still has a cut on his arm and a cut on his lip. What would you do?
Well, you're exactly right, Linda. I certainly would have done that.
I love being right, Francey. I think I love you.
What I would have done is given a very strong first witness. I think the only way to combat a strong defense opening statement is to start the case off right. You know, when I was taught many years ago how to put up a case, you put your strongest witnesses first and last and shove everybody else kind of in the middle. So I hope that's what the prosecutor did here.
And just finally, Steve, common sense or nonsense, the defense case? Common sense or nonsense?
I think it's common sense.
In the chat room, I also want your opinion. Common sense or nonsense? Francey?
I'm going to go with nonsense. How else can I go?
Of course.
Oh, my God. Okay. So we are still following this case. They are finished for the day, but we're going to go back to the defense opening and see whether she followed up. So that was the succinct defense opening, and she said the state will not be able to prove that this was not a self-defense case, that her client was not, when he did the actions against Mr. Knight, was not engaging in saving his own life. So, Francey Hakes and Steve Greenberg, you've been with me most of this afternoon. Steve, how does the prosecution carve out? How do they get back from this hole they're in?
Well, they're not really in a hole yet because the jury hasn't heard any evidence. And most jurors are smart enough to know that, okay, these are arguments and we got to wait to hear from the first witness. But like they just said, you got to start with a real strong witness now. So my guess is that they would start with the girlfriend. And I don't know how strong she is. given the problems that come down the road, but out of the box, she's probably emotional and strong enough.
And Francey, what would you do if you were the prosecution?
Yeah, I think he's right about that. I would definitely put up an eyewitness so long as that eyewitness is strong. And I think really the only eyewitness there, other than defendants, is the girlfriend. And she's going to be emotional. She can tell the story of what happened, what she witnessed, and basically defend her dead boyfriend.
Well, ladies and gentlemen, you have been following the case with all of us. This is the case of our Mr. Baptista out of Florida. He is charged with manslaughter for the death of one Mo Knight. His co-defendant was found guilty some months ago of just culpable negligence, which is a maximum of a year crime. I've been helped by both Stephen Greenberg and Francey Hakes on this today, but there's a lot more to come tomorrow on this case. I mean, we have to hear the evidence from the prosecution, and then we have to wait and hear the evidence from the defense. Now, the next show behind us, as you know, is one of my favorites. It's Aaron Keller's Daily Debrief. And the reason why it's one of my favorites today is I asked Bob Bianchi, as you know, earlier today, is given let's say the blue wave that was occurring. And I want you guys to think about this, because next time you're on, I'm going to answer this. Does the new governor of Wisconsin give Brendan Dassey a pardon? Quickly, maybe you'll answer now. Steve, yes or no? Do you know anything about that case? I'm putting you on the, oh, okay, Francey.
I say yes.
You'd say yes. Stephen, we're going to let you research it and come back. I know I threw you a little bit of a curve there.
I'm not. My daughter's a reporter. She covered the new governor last night in his party.
Okay.
And I would have had her ask him if I'd have known you were going to ask me.
Well, go back and ask her, and we'll report it back to Aaron Keller as soon as she gives you the answer. But, you know, at the Law&Crime Network, we had Jeff Sessions resigning today. We had the Baptista case. We discussed the Dassey case, even though we're not to. But you got to stay tuned for Aaron Keller, because maybe he will give us the answers. In any event, I'm Linda Kenney Baden. Have a good evening. Stay tuned.